Okay, hello everybody, and welcome to this next lecture in our virtual lecture series here at Benjamin Franklin House. Today, we are talking about the trials of James Graham in the revolutionary Atlantic world. In this talk, Dr. James P. Ambuske, digital historian at George Washington Mount Vernon and co-director of the Scottish Court of Session Digital Archive Project at the University of Virginia Law Library, will discuss Graham's journey from slavery to freedom and the questions that this case raised in an increasingly complicated revolutionary world. Jim, welcome.
Well, hi, Caitlin. Hi, everybody. Thanks for inviting me to be with you this afternoon and this evening.
And now I'll turn it over to you.
All right, that's always a dangerous thing, but here we go. Good afternoon and good evening, everyone. To those of you in North America and in Europe, I'm very pleased to be joining you this evening. And thank you very much to Caitlin, Eleanor, Marcy, and all the folks at the Benjamin Franklin House for having me. As Caitlin mentioned, I am the digital historian at Mount Vernon's Washington Library. Where among many of my duties running the Center for Digital History, I also am the host of the podcast Conversations at the Washington Library. I'll just get my screen share going here. A podcast about early American history, Washington's world, and the increasingly complex stories we try to tell about the Revolutionary era. So if you're so inclined and looking for a new podcast to try out, I do encourage you to go to georgewashingtonpodcast.com, where you can see our full episodes and learn how you can subscribe on any of your favorite podcast Apple, Stitcher, Google, what have you. I've been amazed since I started podcasting just how many different podcast apps there are. But today, I want to tell you a story about, based on the research and a digital project that I've been working on for a long time with my colleagues at the University of Virginia Law Library, where I was a postdoc many years ago, and the Center for Research Collections at the University of Edinburgh. And so as Caitlin said, I am the co-director of the Scottish Court of Session Digital Archive Project. I'll tell you a little bit more about that project at the end of today's talk and how you can access it. But a lot of what I'll be talking about is based on a court case that we have in this digital archive. And in particularly the document I'll be talking about in the court case I'll be describing about James Graham comes from the collections of the University of Virginia Law Library. So I want to tell you the story of about a man named James Graham. James Graham was a formerly enslaved individual who became the subject of several lawsuits in the early 1780s when a Royal Navy officer named Lieutenant William Stewart tried to execute a press warrant on Graham and compel him to serve in the Navy. In other words, Stewart tried to draft Graham into military service in this period. And Graham and Stewart's legal battle began in Glasgow, where Stewart was in charge of the impress service, and it ended in Edinburgh before the Court of Session, which is Scotland's supreme civil court. And the question the court had to consider was this: whether James Graham was a seaman according to the terms of the press warrant, which authorized Stewart to, quote, impress seamen, seafaring men, and persons whose occupations and callings are to work in vessels and boats upon rivers, or whether he was not a seaman at all because he had been made to serve aboard ships as an enslaved man. We know about Graham's case because of a single printed 8-page document from the lawsuit in the Court of Session that illuminates not only Graham's trials as an enslaved individual, but I would argue the importance of the slave trade and slavery to Scotland's economic development in the 18th century, the shifting legal foundations of slavery in Great Britain in this same period, and the transformation of a colonial independence movement in North America into an international war. We can make a lot of hay out of this 8-page document. And again, I'll tell you more about these documents themselves in a little bit. But let's begin then by talking about Graham and what we know about him and how we know what we know. And I'll be honest with you at the outset, I have a lot of questions about James Graham's life that I just can't fill into details yet. I don't have answers to them. But I will try to fill in some of those pieces by exploring his world and by discussing some of the evidence that's brought to bear on this court case. And one of the great benefits of a project like this, of the digital project we're engaged in, is that it compels us to ask a lot of these kinds of questions, and it helps us reveal stories that are otherwise have been locked in the archives for a long, long time. And so I'm delighted to share James Graham's story with you today. We know that James Graham was just a boy when a Glasgow merchant named Captain Daniel Graham purchased him on the island of St. Kitts in the West Indies sometime about the year 1757. And so here you see a map of the island of St. Christopher, or St. Kitts as it's called, often called here in the 1770s. This comes actually from the Washington Library's Richard H. Brown Revolutionary War map collection. The Daniel Graham who purchased James may well have been the Daniel Graham whose vessels made semi-annual trips between Glasgow and St. Kitts in the 1760s and 1770s. We know that this Captain Graham bought a variety of goods from markets in Britain down to St. Kitts, where he exchanged them for sugar and cotton produced by enslaved labor. Now, at the moment, I can't say for certain that the two Daniel Grahams are the same man, but evidence I've seen in other sources makes me think that more than likely not, that these two gentlemen are the same people, and that the Daniel Graham we're talking about in this court case is the Daniel Graham who was a prominent Glasgow merchant in this period. James's origins are much more obscure. While we know that Daniel purchased him in St. Kitts, we don't know if James was born there, whether he was taken captive in Africa, survived the Middle Passage, only to be brought to the West Indies and sold to Daniel at auction, or if he was originally enslaved in North America and sold to someone in the West Indies. It's clear that Daniel gave his surname to his newly purchased enslaved boy, but whether or not James was the young man's first name real first name was unclear, although I would suspect that Daniel might have made that choice for him as well. And if that's true, this might indicate an African origin for James. As we all know, purchasers frequently gave non-African names to their enslaved human property once they purchased them. A lot of examples of that in Virginia, certainly as well, when Virginians purchased slaves at the Alexandrian slave market in the 18th century. Depositions taken for this case in the 1780s tell us that in the 1760s, James first acted as the cabin attendant and servant for Daniel while aboard ship, and then over time began to be trained in seamanship so that he could help operate ocean-going vessels. And according to one witness, James could hand, reef, and steer and do other seaman's duty aboard ship in the 1760s and the 1770s. We know that James spent years as Daniel's enslaved man. He served on a number of vessels, sailing between Scotland and the Caribbean, voyages that again saw the exchange of manufactured goods and other items for commodities produced by enslaved men, women, and children, like sugar from the sugar islands of like Jamaica, salt from places like the Bahamas, and cotton in this space as well. The court documents tell us a little bit more about James's life and his relationship with his master, his enslaver, Daniel Graham. We know that Daniel charged his employers for the use of James's time. He kept whatever wages that James would have been entitled to earn as a free man, as a free sailor. For example, we know over the course of what was probably his final voyage as Daniel's enslaved property in 1780, James's wages would have amounted to a little over 28 pounds total, which in today's money would be the equivalent of about 5,000 pounds. So not an insignificant sum of money that Daniel is acquiring as a consequence of charging for James's time to his employers. Daniel kept most of this money, as would have been the common practice amongst people who rented out their enslaved people. And he also earned, and other money earned during James's time at sea as well. He did pay for James's food and his clothing and did give him a little bit of pocket money, but again, Daniel is keeping the bulk of the money that James would have been earning as a free individual. And James is just one of the many enslaved people made to serve aboard trading vessels in the 18th century. A lot of scholars are doing a lot of great work these days, uncovering the role of enslaved people aboard ships. My colleague Mary Hicks, for example, is doing some excellent work looking at Brazilian enslaved people who are serving aboard vessels trading throughout the Atlantic world. And as such, James Graham was an unwilling participant in a transatlantic network that bound Scotland, the Caribbean, and North America together through slavery. And now historians, as we might know, have done a lot of great work looking at the transatlantic tobacco trade that yoked Scotland and North America together. Scotland's great tobacco lords, men like Alexander Spears, William Cunningham, John Glassford, these men amassed, and their companies, they amassed enormous wealth, trading for tobacco with planters right here in Virginia, where I am now. I'm not too far, even though I work for George Washington's Mount Vernon, I actually live not too far from Thomas Jefferson's Monticello. Spears, Cunningham, Glassford, and a variety of other merchants traded with Virginia tobacco planters, using credit to facilitate those relationships and amassing enormous sums of wealth here out of Virginia, but also in Maryland as well. It's no accident, right, that there is a Virginia street in Glasgow, and then on that street you find a lot of the counting houses and a lot of the great mansions that these tobacco lords built, all on the backs of profits born on the backs of enslaved people. Now, scholars have also done a lot of great work in recent years looking at sugar profits coming from the West Indies. And in recent years, they've been paying much more attention to Scotland's role and connection to the West Indies. And, we know that Scots played a critical role in places like Jamaica, both as government officials, as plantation owners and merchants. But what has been really fascinating in recent years is what scholars like Stephen Mullen and Andrew McKillop and Ian McKinnon have been doing to trace capital flows from the West Indies back to Scotland to see how slavery is making an economic impact in Scotland itself. And we know this, and the research is showing that this is having an impact not only in lowland cities like Glasgow, where we might expect to see that because a lot of the merchant houses are there. Glasgow is a main Atlantic port for Scotland, but we're also giving to understand in much greater detail how all of that enormous wealth is flowing from the Caribbean into the Highlands and Western Islands, so that landowners can not only purchase more property, but they can expand their property holdings and expand and fund the kind of lifestyles that they were accustomed to as members of the landed aristocracy. McKillop and McKinnon, for example, have recently shown that the equivalent of more than 100 million pounds flowed from the Caribbean to flowed from the Caribbean and North America to Scotland in the 18th and 19th centuries. And they've also identified 63 estates in the Highlands and Islands purchased using wealth derived from slavery. So James Graham, the man whose story we're telling today, was one element in this much larger enterprise of slavery and slave trading that powered the economy in the Atlantic world in this period. We know that in 1779, Daniel Graham, who purchased James Graham 2 decades earlier, in 1779, Daniel decides to retire from the merchant business. The following year, he takes one more voyage to the West Indies, bringing James along with him, before returning to Britain in January 1781. And in November 1781, we find that Daniel apparently freed James. And I will explain my choice of apparently in just a moment, because it is a complicated story between slavery and freedom by the late 1770s, early 1780s. Nevertheless, in November 1781, it does appear that Daniel freed James and begins to set in motion a sequence of events that will eventually land us before the Court of Session not too much long after that. About a month later, roughly about December 1781, James becomes an indentured servant to a Glasgow carpet-making firm, and he agrees to a 5-year contract of service. And he strikes this contract so he can learn to become a carpet weaver, which was a critical industry and a useful trade in a critical industry in Glasgow, and is a much larger part of Scotland's woolen industry in the 18th century. So it appears that he's taking his new freedom He's entering into a legal contract of his own volition and agrees to become an indentured servant and learn the trade of carpet weaving in this period. It does lead us to ask the question, though, well, why does Daniel free James when he does? And I'd like us to think about a couple of reasons in that regard. One perhaps might be obvious. When Daniel decides to retire in 1779, he was nearing 60 years old. He might not have had any, no longer had any need for an enslaved individual like James, or either as a servant or as an enslaved mariner. And as a consequence of his advancing age and his desire to get out of the game, he decides to free James outright. Perhaps as gruesome as it is to consider, Daniel had thought he had gotten his money's worth out of James and just decides that he's going to free him. Okay, if that's the case, why not sell James to somebody else? Why not try to make more economic benefit out of this enslaved individual to shore up your retirement, to acquire some much needed funds? Why not sell him to somebody else? And here we have to remember that in 1781, James is in Britain. He's gone on that final voyage with Daniel Graham. They've gone down to St. Kitts and they come back in 1781 to Britain where they live. In 1781, James is in Britain. And that's really important here because by 1781, it is against the law to remove an enslaved individual from England, Wales, or Scotland without a person's consent. And so in essence, slavery was illegal in the British Isles. And this was the result of two very important court cases in the 1770s. One of which you've already may have heard about, and is actually the more famous court case that did excite, in a negative way, excite some American revolutionaries when they were resisting British authority during this period. The most famous case that we can think about is the case of Somerset v. Stuart in 1772. In 1772, the Court of King's Bench in England ruled in this case that slavery had no basis in English law. And just very briefly, this case involved an enslaved man named James Somerset, who was purchased in Boston by a customs official named Charles Stuart a few years earlier. To make a long story short, after Stuart brought Somerset to England, Somerset escaped for a time before Stuart recaptured him and tried to sell him to buyers headed for Jamaica. Some of Stuart's benefactors petitioned the court on his behalf, and following a hearing before Lord Chief Justice Mansfield and the rest of the court, the Lord Chief Justice issued the court's opinion that said, in essence, legal slavery could not exist in England without an act of Parliament. And as Parliament had not passed such an act, slavery did not exist in England. And as a consequence, Somerset could not be removed from England against his will. Now, importantly, however, that ruling only applies to England and Wales. It doesn't apply to Scotland because Scotland still retains, then as it does now, its own legal system following the British Union in 1707. So England, of course, is a common law country. Scotland is a civil law society. So they have two distinct legal systems operating on the British Isles. And a precedent set in England doesn't necessarily control any kind of legal action in Scotland. So 2 years after Somerset v. Stuart in England, an enslaved man named Joseph Knight, who was then living in Perth, begins legal proceedings of a similar nature that eventually makes its way to the Court of Session in Edinburgh. Now, this is a lesser known case. This is the case of Knight v. Wedderburn. And Knight was born in Africa. He was purchased by a man named John Wedderburn in Jamaica in the 1760s, and that Wedderburn brought him back to Scotland in 1769. Like Somerset, Knight absconded from his master and resulted in his arrest. Eventually, that case becomes before the Court of Session in Edinburgh in 1778. And the judges ruled 8-4 that slavery had no basis in Scots law and that enslaved people could not be removed from Scotland without their consent. So in both instances, both the Somerset v. Stuart case in England in 1772 and the case of Knight v. Wedderburn in 1778 in the Court of Session in Scotland, Both courts said that irrespective of whatever colonial law had to say about the legality of slavery, these two cases established slavery had no foundation in English or Scots law. So Jamaica might have legal slavery, Virginia might have legal slavery, and there's a lot of great work on the ways in which these two slave societies developed laws to make slavery possible and economically and socially important to these two colonies, regardless of whatever those two places said, or any other colony that had slavery. Slavery had no basis in English or Scots law. So it's in this legal context in 1781 that Daniel Graham apparently freed James Graham. And again, I use the word apparently because the court documents involved in James Graham's case don't actually use the term freed. Rather, they say that James, quote, relinquished his service with Daniel. So they don't use that term. They make it sort of more ambiguous. So perhaps one or both men were aware of the Court of Sessions ruling in 1778. And if so, this raises a whole set of new questions. Did James agree to go on this 1780 voyage on his own? Did Daniel convince him to go through some means of subterfuge? And at what point was James aware of his changing status within Scotland itself? These are great questions. I think the great questions that demand answers, and they both point to the certainty, but also the great ambiguity that these legal decisions created in Great Britain on the question of slavery in the final quarter of the 18th century. Nevertheless, though, we know that by 1781, Daniel technically could not take James out of Scotland without his consent, that James apparently became a free man, and that he signed a contract with the Glasgow carpet making firm Grant Wood and Company for a term of 5 years service. So early the next year, early in 1782, Lieutenant William Stewart, the impress officer for Glasgow, served a press warrant on James Graham to draft him into the Royal Navy and placed him in prison until such time that he could be put aboard ship to complete his service or to begin his service. That early 1782 action triggers the case that we're discussing today. The Lords of Admiralty empowered Lieutenant Stewart and other impress officers at the time to quote, and again, to quote, impress seamen, seafaring men, and persons whose occupations and callings are to work in vessels of boats upon rivers. Now, in many ways, this was a routine practice. The Royal Navy was the backbone of the British Empire and Britain's primary offensive and defensive weapon in the 18th century. The British adopted a blue water strategy early in the 18th century, made that the primary means of their defense, and also to project military and political power across not only the Atlantic, but the globe. But by the early 1780s, drafting men of the Royal Navy had taken on a much greater sense of urgency because of events in North America and in Europe. In 1788, the same year that the Court of Session issued its ruling in Knight v. Wedderburn, the American War for Independence had taken a dramatic turn, and it morphed from a colonial rebellion into an international war for Great Britain. After secretly supplying the American rebels for years, France signs a Treaty of Alliance in 1778 with the American Continental Congress and openly declares war on Great Britain. So 20 years after defeating France in North America in the 7 Years' War, sometimes known as the Great War of Empire, Great Britain's old enemy rears its head again to side with the American rebels and raise a whole host of threats that now the British have to think about as they plan their military strategy. Now Britain has to worry about the defense of the home islands. They have to worry about the threat of a cross-channel invasion, and they begin redeploying forces out of North America back home and in other places to counter this emerging threat. And the British also make greater efforts to defend its colonies in the West Indies. And we have to keep in mind that West Indian colonies like Jamaica and Barbados, these are the most important colonies in North America for the British. Yes, the mainland colonies, the 13 colonies that are rebelling, yes, they're important to Britain's economy, they're important to its political power, but in many ways, the West Indian islands are kind of like the ATMs of the 18th century. These things just print money. and the British are very keen to defend them and to make sure that the French do not capture any of the valuable colonies like Jamaica, like Barbados, and like these other islands. So the transformation of the American rebellion into an international war with France places greater burden on the Royal Navy to defend British interests in the Atlantic world. And so it's no surprise then, right, that Lieutenant Stewart is probably looking for every able-bodied seaman he could possibly find to press into service. The Royal Navy needs bodies in this new international order. But when he served that press warrant on James Graham and put him in prison, James's new employers, again, that Glasgow firm, Grant, Wood and Company, lodged a petition with the Glasgow merchants arguing on James's behalf that, they had a contract with James and that James was not a seaman, according to the definition of the press warrant. Now, Lieutenant Stewart, of course, argued that James was a seaman. How could he not argue that? He produces a great deal of evidence, including witness testimony, including from Daniel Graham himself, to show that in addition to James acting as Daniel's servant aboard ship, he had clearly learned to operate ships and had done so on many occasions. And so in Stewart's mind, James Graham is an able-bodied seaman. He is somebody who knows how to operate a vessel. He knows essentially the ropes, so to speak. He will be right at home on a Royal Navy vessel and fit right in with the service. So James's employers filed this petition on his behalf. They try to get him released, and they argue before the magistrates that he does not fit the definition of a seaman as included in the press warrant. The magistrates rule in James's favor. In March 1782, they issue an opinion that read in part, quote, James Graham, during the time he was at sea, was a slave to the said Daniel Graham, his late master, and he was obliged to obey his commands, and that no evidence has been brought that the said James Graham freely and voluntarily made choice of a seafaring life. Arguing then, in other words, that because he was an enslaved individual, he had never been given the choice freely and voluntarily to learn the trade as a seaman, and so therefore he does not fit the definition of that press warrant. They ordered that James be released from prison and instructed Lieutenant Stewart to leave him alone. Well, unsurprisingly in many ways, Lieutenant Stewart was undeterred, and he appealed this ruling before the Court of Session, and he feels like he's got a pretty good case. The evidence he believed, that the evidence that he brought to the magistrates in Glasgow, he thought was pretty sound. He's feeling that he has a very strong case that James, in fact, does fit the bill of a seaman according to the terms of the press warrant, and that he's got the witness testimony and he's got the other evidence to prove it. So in July of 1782, he gets a hearing before the High Court in Edinburgh. Now, just a little bit about the court to help us sort of understand how this process plays out. The Court of Session in this period was divided into two parts. It still is. It's a little more complicated now, but in this period, it's a little simpler. It's divided into two parts, the outer house and the inner house. In the outer house, one of the judges would sit as what was called the Lord Ordinary and conduct something like a preliminary hearing. Now, if you go to Edinburgh today, and if you go to the Court of Session, which is still near St. Giles Castle, if you go into what was the old Scottish Parliament Hall, this big, beautiful hall with these gorgeous timber beams from the forests of Fife, the old Parliament Hall served as the outer house for the Court of Session. And so in that space, James Graham's case would have been heard by the Lord Ordinary. And if the Lord Ordinary would normally have sort of the first hearing for cases like this, but if the Lord Ordinary had thought that a case was too complicated for one judge to consider alone, or if one of the litigants wanted to appeal to the full court, a case would then move from the outer house to the inner house, where all 12 judges would hear the case. So in July of 1782, Lieutenant Stewart presented his case to the Lord Ordinary, who promptly confirmed the Glasgow magistrates' decision. But Lieutenant Stewart is a persistent fellow, so then he asked for a full court review. And in August of 1782, the naval officer presented his evidence to the 12 judges on the Court of Session. And in doing so, Lieutenant Stewart's advocate, or his lawyer, advanced what I think are some really remarkable arguments based on race that speak to the question of how the law should treat formerly enslaved people, whether they were citizens of Britain as well as subjects of George III, and what the obligations they owed to the nation as free people. And so after repeating the same evidence presented in previous hearings, both at the Glasgow level and to the Lord Ordinary in the Outer House, Lieutenant Stewart's advocate, who is a man named Robert Blair, argues something quite interesting. He argues the only question is whether the circumstances of James Graham being a Negro bestows upon him any special privilege not to be seized by a press warrant, although a stout, able-bodied man perfectly fit to do duty on shipboard. For the petitioner cannot suppose it would even have been held as a matter of doubt or maintained that a white seaman, under the circumstances above mentioned, would not have been liable to be impressed. So Blair, the advocate, then, is asking the court to consider this case in light of those earlier decisions on the legality of slavery in Britain, arguing that if those cases intended to give formerly enslaved people equal protection under law, then James Graham was in a sense asking the court to go one step further and declare, as he later says in another passage, that, quote, Negroes are not only to be free, but much freer than any other person of the same profession who has the misfortune to have a white complexion, end quote. So if James and his supporters were trying to use his status as a formerly enslaved person to resist impressment, Lieutenant Stewart and his legal counsel did attempt to make race-based claims about James's eligibility for impressment by building on the foundation of those earlier rulings to suggest that if James won his case, it would create unequal protection under law. And I think these are a really amazing set of arguments in the sense that they show us how people, courts, and the law in this period are trying to figure out these questions of slavery, of citizenship, and what freedom really meant for formerly enslaved people throughout the Atlantic world. This is a period in which the underpinnings of slavery are increasingly questioned. This is certainly the case through in the early 19th century as Great Britain charts a more abolitionist course, although it's a slow, very painful process, as we have seen in recent weeks when stories about a very prominent politician named Henry Dundas essentially slow-walked abolition bills in the late 18th century, and also in North America, where abolitionists are increasingly pressing against the slaveholding societies in the South. And of course, that leads ultimately to the American Civil War in many ways in the 1860s. But it's in this moment when we start to see a lot of these questions arise. What is the legal status of formerly enslaved people? What rights do they have? How does the law adjudicate claims that span the transatlantic world? How do they treat laws that come into conflict with each other? How are enslaved people supposed to navigate freedom in Great Britain? All of these are coming to a head, and James Graham's case helps us illuminate this. And no doubt, right, of course, we hear echoes of both sets of arguments in our own time as we continue to wrestle with the legacies of slavery and of racism in our respective countries. James Graham won this case, or at least won this round. We know that the Court of Session refused Lieutenant Stewart's petition, and we know that because someone at the time wrote the court's decision on the printed document to submit it to the judges for the review. And you can see here on the screen a close-up of the marginalia on this printed session paper, and you can see in two places in the darker ink it says refused. That is in the hand of a man named William Craig, Lord Craig, who about 10 years after this document is printed, he sits on the court as a judge, but at the time he's an advocate, and so we believe that this document belonged to him. And you can also see that at some other point in time, somebody wrote in a different hand, the court refused this petition. Now, frustratingly, it doesn't tell us why the court refused the petition, only that they did. And so perhaps the court simply agreed with earlier rulings and found no reasons to intervene. Maybe they were reluctant to take up the kind of questions that Lieutenant Stewart's legal counsel raised and decided to avoid them entirely by refusing the petition. It's also possible that the case did not end here. The case that I've been discussing today, as I said, is but one of the cases that my colleagues and I at the University of Virginia and the University of Edinburgh are trying to reconstruct by digitizing session papers, the printed documents submitted to the Court of Session, like the one that you see here. These documents were printed in very limited quantities. They remain largely uncatalogued in UK and US North American library and archives, and they are difficult to access and interpret unless you really know what you're doing. So my partners and I are working very hard to make these remarkable stories and these remarkable materials much more accessible so that we can tell stories like James Graham and his place in the revolutionary Atlantic world. And actually, in fact, I invite you and encourage you to read over James Graham's case yourself after this talk is over. And you can do so by heading over to our project website, which is called, you can find it scos.law.virginia.edu, or just Google Scottish Court of Session Digital Archive Project. That'll take you right to it. In this digital repository, you can find James Graham's case. If you simply just use the search feature to put in James Graham, his case will come up, Stewart v. Graham, and you can read the document for yourself. And you can also make your own discoveries. We're adding new documents all of the time, and I would love to know what you find. Because what I would argue, as I'm coming to an end of my talk, and I'm really excited to take your questions, what I would argue is that James Graham's case shows us, and as I've tried to highlight over the course of my time with you today, is that his case has a lot to tell us about one person's journey from slavery to freedom. It has a lot to tell us about the importance of slavery to Scotland and Scottish society and Scotland's economy. It has a lot to tell us about the increasingly complicated legal world of slavery in Britain in the final quarter of the 18th century. And it also has a lot to tell us about the transformation of the American rebellion into an international war. So I'm excited to take your questions here in a minute. I'm very pleased that I've had the opportunity to tell James Graham's story. I think there's a lot more to discover about his story, and when COVID is over and I can get back over there to the UK to visit not only my friends at the Benjamin Franklin House, but head north back to Edinburgh and to Glasgow, I'm hoping to find more information there. And so stay tuned. There are so many parts of this story that await discovery, but I'm glad that I had the opportunity to begin to present some of my preliminary findings here. And so I'll stop and just say thank you again very much for your attention, and I welcome your questions and look forward to them.
Thank you so much, Jim. That was really interesting. And I see we have a couple of questions already, but before, I wanted to ask you a question.
Sure.
What do you think was, so I know that you said that the project is kind of bringing all these documents to light. So I was just out of curiosity, is there a favorite document that you found so far from the work?
Oh my gosh. The joy of working on a project like this is that you find something new every day. Or I don't get to work on it all the time because it's not my primary job, and so I do it after hours, of course. And so, but I don't know if I have one. I mean, there's just so many remarkable things. We've found, this case with James Graham. I'm finding a lot of cases in which American loyalists after the war are litigating disputes that stem from the war before the Court of Session. We have found copyright disputes over the Encyclopedia Britannica. And the fascinating thing about these documents is that it's not simply just the legal arguments that you see presented here. They not only print the documents like you've seen here, but they also print the evidence. And so there'll be instances which we have reproductions of account books. There's a logbook from a not slave trading vessel, but a merchant vessel from Scotland to Honduras in which slave people served. We have wonderful correspondence between, it's wonderful in the sense that we get to read it. It's not so great because it's about a divorce case, and you can see the breakdown of a marriage over the course of about 2 years through letters that are printed in these court cases. So it's hard to say that I have a favorite document. If I probably had to say, I think actually that marriage case, and the name of it escapes me right now, but it's on our website. It might be my favorite just because it is a concrete example, like actually James Graham's case, where you see the human complexity at work, and how even though at first glance you might get into a case and you're reading a lot of legal knowledge and all this stuff that makes no sense to anybody but hyper specialists, you get the human dimension at work, and you see people at the height of their joy, but also in the depths of their pain at any given moment. And it's sort of a privilege to be able to bear witness to that kind of stuff.
Thank you. I mean, we at Benjamin Franklin House, we kind of experienced that through the Franklin Papers, which kind of shows in depth kind of the highs and the lows of his life. So it's as a historian, I'm sure must be a moment to be able to see those kinds of, as you said, human complexity.
Absolutely right.
So we do have a few questions that have come through. We have Niels Nielsen, who asked, did the Church of Scotland shape how Scottish people thought about the humanity of slaves, and either to perpetuate slavery or to advocate for abolition?
That is a really fantastic question, and I don't really know the answer. But I think that's probably one avenue that probably needs to be some work done. I will say that from what I know of sort of that relationship, for example, John Witherspoon, who was preaching in Paisley, just to the north of Glasgow or in and around Glasgow before he immigrated to the United States. Well, it wasn't the United States, it was the American colonies in 1768, to become the president of what is now Princeton. He did have some interactions with enslaved people. It's not, I think he actually had, if I recall correctly, an enslaved person himself. And so it didn't seem to have any kind of necessary moral qualms with it. But it's a great question that I don't want to say much more because I don't really know. But I think it would be a fascinating research topic for someone to take up. And especially now, because the National Records of Scotland has just made available a huge collection of Kurt Session records, where you can go in and explore the kinds of debates that are taking place in the Scottish Church in this period in different parishes around Scotland. So this would be a wonderful opportunity to use those resources for that kind of question.
So we have the next question, which can you tell us something about James Graham's descendants, if he had any?
I wish I knew. I don't. Unfortunately, I don't know much more about James beyond the finality of this part of the court case in 1782. One of my goals, and I think one of our goals, is to find out more about Graham's life, not only before he comes before the Court of Session in the 1780s, but more importantly after, because I think that can help us understand what it's like for individuals like him who were formerly enslaved, but then come under the dictums of these rulings in 1778 that essentially outlaw slavery in Scotland itself. And what does that mean for his life? We've seen throughout this case that he contracts himself out as an indentured servant in late 1781. What happens to him after that? Does he build a life for himself? Does he have a family? How does he navigate this blurred line between slavery and freedom in Scotland? I don't know, but I hope to find out at some point.
So the next question we have is, were court cases such as this usual with the Royal Navy? Was Stuart under pressure to meet a quota of impressing seamen, thus bringing a petition against James Graham?
Yeah, it's a great question, and thank you for it. It's one I thought about a lot. I don't recall that we've seen too many press warrant cases in our collections, but that doesn't mean that they don't exist. And it's a concrete example of what we're trying to do with our digital project. Because Scotland is a civil law society, which meant that they had less need for judicial precedent than, say, common law England or here in the United States. Many of the cases, including this one, including James Graham's case, were never published in law reports. And it also is a reflection of the fact that the documents that I've showed you today, yes, the Faculty of Advocates Library in Edinburgh or the Writers to the Signet Library in Edinburgh collected these documents, but they were often the very highly personal collections of individuals like Robert Blair, who was the advocate in this case, like Lord Craig, who I mentioned earlier. These were very highly curated things. So they often selected what they wanted to keep because they thought they were important, or because they were a part of that case, and discarded what they did not want. So that is a long answer to say is that the bulk of session papers from the 18th century are not cataloged. Part of our goal is to use digital technology to expedite that process so that we can begin to uncover stories like James Graham's. So I'm willing to bet that in this case, well, not in the court case, but in this instance, that when we begin digitizing more of these materials and subjecting them to advanced technology that allows us to unpack them, I would imagine we're probably going to find more press warrant cases. Now, to your point, your question about Stuart feeling the pressure, I would probably say so. Given the military emergency that Britain now finds itself in by the early 1780s, having to worry about defending against cross-channel invasion, having to defend Gibraltar. The Spanish, of course, are very keen to take Gibraltar back from the British, still are. That's still a sticking point for them. And the British having to defend their valuable colonies in the West Indies. So there's a real sense of urgency and real need for manpower in this period. And again, as the Royal Navy is the kind of the backbone of Britain's offensive and defensive capabilities, Stuart is probably out there looking for every person that can row a boat at this point. Thank you for the question. That was great.
Thank you for that. And actually, interestingly, we had a virtual lecture a few months ago where they talked about the case of kind of a similar case. It was Dr. Johnson's heir, and he was an enslaved man who then joined the Navy. So it seems to be a common theme that the Navy seems to be very much a part of these kind of the lives of enslaved people. And I don't know if it's because there was a chance to maybe make a name for yourself in there. I mean, obviously some people, some of them were forced into the Navy, but that those who did succeed, that maybe that was an avenue for them to kind of make a name for themselves. I don't know if you have any thoughts on that.
Well, I mean, possibly, but one of the things I think what might be advantageous, as you say, some of these, like James Graham, were forced to be a civilian, well, quote unquote civilian, mariners, but also, sometimes they would attempt to go into the Royal Navy. But it might be a chance for wages that they don't have access to in Britain. Certainly, they're probably not inclined to go try their luck in the West Indies or North America, where even if you're a freed individual, the odds are you could be captured and sold back into slavery in some form. So it's probably a good chance to make some kind of livelihood. A lot of especially commercial crews are multi-ethnic, multi-race in this period, so it would not have been unusual for a person of color to serve on a ship, and so there might have been a number of reasons why they would have selected to choose service. Possibly, as we saw on the American context, both in the Revolution, but especially in the American Civil War, service might be a pathway to citizenship, and to really prove one's worth and to be worthy of equal protection under law and to some measure of equality. So there might be that incentive there as well.
Kind of touched on this a little bit, but we had a question about what sort of crew would have been part of and what can we understand about his role and treatment on board the ship. So you mentioned it would have been a kind of a multi-ethnic environment, but do we know much about how he would have been treated specifically on board?
Yeah, it's a great question, and I guess it depends on the context. And we don't know much more about Daniel's relationship with James than we have from this document here. And so, as we know, right, slavery in general was very brutal, but there are instances where it could be particularly brutal if you had an especially cruel master who, took whatever license he had with an enslaved individual. And so, he could have been, extremely difficult, made James's life extremely difficult. But in general, if you're slaving on board a ship, of course, he's enslaved, so he doesn't have much of a choice in the matter. But he, probably would have been seen, of course, as a lesser individual by the white officers or the white crewmen, and so there would have been a hierarchy there as well. But they did have to operate the ship, and so when you're at sea, you do have to rely on each other to make sure you don't die, essentially. So it's a great question, and as I said, my colleague Mary Hicks, who I went to graduate school with here at the University of Virginia, has been doing some great work on enslaved mariners who were plying the waters between Africa and Europe and South America. And so she's got an important book coming out. I think hopefully in a couple of years that'll really highlight that dynamic. I think there's more to do on this question for Britain, for Scotland, for North America in general. We don't know enough. Unfortunately, naval history in all its forms, commercial or military, sometimes takes a backseat to what's happening on land, or takes a backseat to the economic transactions that we see. But it would be great to know a lot more about what it's like to actually be on a ship, and hopefully we'll get some more scholarship and some work on that head.
We had a follow-up question to the idea of Stuart kind of trying to impress as many seamen as possible, but do we know if he would have been paid a bonus, so to speak, for each man he brought in?
That's a great question. I don't know the economic incentive structure well enough, whether or not that would have been the case. There has been some great work on impressment in the 18th century. And actually some recently books that have been published that have touched on that topic. But, unfortunately, I don't know that question well enough to know whether or not that would have been the case. But it's an excellent question. Somebody out there knows, please chime in. Let's make this a group effort.
Yes, the chat function is available. So if anybody does know, you're welcome to contribute. So we have actually time for one more question. And we just happen to have a last question, so perfect timing.
Easy enough.
Has your research turned up anything about how formerly enslaved people were welcomed in Scotland at that time?
Yeah, so there's actually, I'll point you to a colleague of mine named Simon Newman, who was at the University of Glasgow. I believe he's now at the University of Wisconsin, but he's written a lot about the lives of, or at least an article about enslaved people, quote unquote, runaways in Great Britain. And he's also written a lot about runaways in Jamaica as well. And so there's some great work there on in Jamaica, the enslaved people who ran away could, because of the demographic nature of Jamaican society, can kind of fold into of the background and try to maintain their nominal freedom by blending in. Difficult question in Great Britain, though. I think at the time of Somerset v. Stewart, there was something like 15,000 people of color who were living in Great Britain at that moment. And given the attitudes at the time about race, about the worthiness of one quote unquote race as opposed to the other, they're going to experience and have difficulties, just as you might expect in places like Philadelphia or New York or other Anglo-American or Anglo-centric cities in the Atlantic world in this period. They're going to be of a lower status. They'll have less opportunity to rise above their station. They'll probably be working in less advantageous jobs. And so, that might get back to the question of why, go into the Royal Navy of your own volition as a chance to earn better wages. So they're going to be subjected to these same kind of social, economic, and racial hierarchies you're going to be seeing throughout the rest of the space in this period.
Thank you very much, Jim, for your time and for your research. Very much appreciated and very interesting. I'm sure that people will go look at the project after you've spoken about this. So thank you again.
Well, thank you. And if anybody else has any questions, feel free to reach me via email, or actually on Twitter. I'm at James P. Ambuske on Twitter, because I'm not that clever to come up with a fancy handle. Or you can email me through my website at jamespmbuske.com. I'm happy to answer questions about our digital project, and happy to speculate with you about James Graham's life or anything else you want to talk about. But thank you, Caitlin. I really appreciate this. This has been terrific. And thanks to you all out there that I wish I could see your faces, and maybe when this is all over, we can do this in person, but it's been terrific.
Thank you. And this recording will be available on our website, www.benjaminfranklinhouse.org. So check it out, and we hope to see you at our next lecture. And thank you again, Jim.
Thank you. Bye, everybody.